Uno, 2, 3, 1, 2, 3, una prueba de sonido para redes sociales, 1, 2, 3.
Muy buenos días, doña Gabriela.
Buenos días, Douglas, ¿cómo estás?
Hola Gaby, buenos días.
Hola, Pamela, ¿cómo estás?
Bien, ¿y usted?
¿Todo bien? Ariana, buenos días.
Ariana,
Buenos
yo ya te
días.
iba a llamar. Se acaba de conectar el perito.
Sí, pero como ya están jueces y doña Gabriela, entonces, ¿no es posible mandarle un mensaje a sala de espera o no? No en esta versión de Zoom. Ok,
No,
bueno, yo le escribí a los abogados, espero que le hayan pasado el mensaje.
¿Cuál es
Gracias.
el mensaje? O sea, pasarlo
sobre fondo y eventuales reparaciones y costas en el caso Puracal y otros versus Nicaragua. Corresponde ahora recibir la declaración del perito propuesto por el representante de las presuntas víctimas. Posteriormente, la representación de las presuntas víctimas expondrá sus alegatos finales orales sobre el fondo y eventuales reparaciones y costas en el presente caso, y la representación de la Comisión Interamericana de Derechos Humanos expongará sus
Human Rights
observaciones
will
finales.
give its final
A
closing
continuación,
observations.
receberemos la
We will
declaración del
now
perito
receive a
propuesto por el
statement
representante.
from the
Solicito
expert
a
witness
senhora
proposed by the
secretária adjunta chamar a
representatives.
declarar al perito, tomar sus datos y
The
realizar
Assistant
las
Registrar,
prevenciones
please invite the expert witness
Gracias,
to come
presidente.
and take
Buenos días.
his
Se
particulars.
llama a declarar
Thank you.
a Justin
We
Brooks.
now call Justin Brooks to speak.
Buenos días, señor Brooks.
Good
¿Me
morning, Mr.
escucha bien?
Brooks. Can you hear me?
Sí, buenos días.
Buenos
Yes, good
días.
morning.
Quiero compartir
Se
una-
solicita, primero vamos a hacer
First of
unas
all, we need
precisiones,
to
darle
give
unos
you some
datos y después va a
explanations
poder
and
rendir su
information, and then you
peritaje.
can proceed with your
Se
expert
solicita al
statement.
declarante
The
manifestar ante la
please
corte su nombre,
tell the court your name,
nacionalidad, lugar de
nationality,
residencia,
and
por favor.
domicile.
Mi nombre es Justin Brooks.
My name is
y
Justin
soy
Brooks.
ciudadano de los
I am
Estados Unidos
a citizen of the
y vivo
United
también en los
States, and
Estados
I
Unidos.
also live in the United States.
Gracias.
Thank you.
El declarante deberá limitarse a contestar clara y
Please
precisamente las
answer
preguntas
the
que se le
questions clearly
formularán.
and
Se
specifically.
informa al señor Justin Brooks que fue citado por
Justin
la
Brooks, you
corte
were
para
brought before
declarar
the court
sobre los
to make a
marcos
statement
normativos,
concerning the
regulatorios y las
regulatory
prácticas
and legal
indispensables para
frameworks and
atender los casos de
practices which are
personas víctimas
necessary
de
to
condenas
defend the cases
cerradas
of people
y la
who are the
reparación
victims
integral de
of wrongful
personas condenadas
convictions
siendo inocentes.
and
Se
the
informa
situation of
que,
people
de
who are
acuerdo con el
convicted while
artículo
when they're
53 del
innocent.
reglamento de la Corte, los
Article
estados no podrán
53.
enjuiciar a la
Be
presunta
advised that
víctima,
in
a los
keeping with Article
testigos y a los
53 of the
peritos,
Rules
a
of
sus
Procedure, states
representantes o
may not
asesores
institute
legales,
proceedings against
ni ejercer
witnesses, expert
represalias
witnesses, or
contra
alleged
ellos y
victims,
sus
nor their
familiares a
representatives or
causa
legal
de sus
advisors, nor exert
declaraciones,
pressure on
dictámenes
them
rendidos
or on their
o su
families on
defensa
account of
legal ante la
statements,
Corte.
opinions, or legal defenses presented
Seguidamente,
to
el
the court.
presidente de la Corte procederá a
The
tomar el
president of the court
juramento
will now
de rigor al
swear,
perito.
Senhor
have you be sworn in.
jura ou
Thank you.
declara
Do you
solenemente
swear
que
or
exercerá
solemnly
sus
profess
funciones de perito
that you
con todo
will
honor y con
perform
toda
your duty as an
consciencia?
expert witness honorably and
Sí,
conscientiously?
claro.
Yes, I do.
Muchas gracias.
Thank you.
Antes de ser interrogado por los
Before being
representantes,
examined by the
el señor
parties,
perito tiene la
the expert
posibilidad de
witness will be
presentar
granted
una exposición libre de máximo 10 minutos
up to 10
referente al
minutes
objeto de
to
su
make a free
declaración,
statement on the
que
purpose for
consulta
which he
sea
was
al
brought
uso de
before the
título.
court.
Muy bien.
Adelante.
Ok. Tengo un PowerPoint y es posible compartir.
I want to share a PowerPoint.
Ahora sí. Bueno, me llamo Justin Brooks.
My
y
name is
soy
Justin
profesor
Brooks,
en
and
la
I am
Universidad
a
de San
professor
Diego,
at
Facultad de Derecho,
San Diego University
y
Law
soy
School.
fundador del
I am the
proyecto
founder of
Inocente
the Innocent
en California.
Project in
Tengo
California.
casi 40 años
I
trabajando
have
en
been
casos de
working
los
for nearly 40
inocentes
years on cases of
en los
innocent
Estados
people in the
Unidos,
United
América
States
Latina,
and in Latin
Europa.
America,
Hoy
Europe,
estoy en
and today
Inglaterra
I am
enseñando clases en
in
condenas
England
cerradas.
teaching a
Yo he
course on wrongful
escrito
convictions.
muchísimos
I have written a
artículos
great deal about on
sobre
the
casos
subject, many articles
inocentes
on cases
y
of
dos
innocent people,
libros.
also 2
Y,
books.
yo enseño clases en este
I
tema
also teach on the
a
subject.
policía, a estudiantes,
I
a
teach to
abogados,
police, to
jueces.
students, to attorneys, to judges.
Eso es mi
So
especialidad.
that is my
Bueno,
specialization.
después de casi 40 años
After
trabajando
nearly
en
40
casos de los
years
inocentes
working
en los
in
Estados Unidos,
cases of innocent
ahora se han
people in the
documentado
United States, 3,689 cases have been documented of wrongful
solo en los
convictions
Estados Unidos.
only in the United States
Por
alone.
supuesto, hay casos de
Of
inocentes
course,
en todo el
there are
mundo,
cases of innocent
como
people
los
imprisoned
Estados
all over the
Unidos.
world,
Y como
as in
hemos
the United
probado la
States,
inocencia,
and since
bueno, tenemos un
because
proceso de habeas corpus
how have we
en
proven
los
innocence?
Estados Unidos.
We have a
Es
process of
posible
habeas
abrir
corpus
un
in the United
caso
States, and it is
años,
possible to
décadas
reopen a case years or even
después de
decades
juicios
following
orales, si nosotros
the
tenemos
trials
pruebas
if we have new
nuevas,
evidence,
nuevas forenses o pruebas nuevas como nuevos
forensic evidence, for
testigos,
example, or
otro
new
tipo
witnesses
de
who have
evidencia.
come up, or other types of
Y ahora
evidence.
sabemos mucho sobre las
We know a
causas
great
de
deal
las
now about the
condenas cerradas.
causes of
Después de
wrongful
estudiando
convictions
todos
after
estos
having
casos.
studied all these cases.
Número uno, por ejemplo,
Number one,
representación deficiente de
inadequate
la defensa,
defense representation. Number
identificaciones
two, mistaken eyewitness identification. This is a serious problem all over the world with the processes that the police used for identification. Another is false confessions. We know now that innocent people do sometimes confess in nearly 17% of all cases of people who are innocent. And faulty forensic evidence, as in this case, police misconduct, also as we see in this case, judicial misconduct and systemic injustice, which we also see in the instant case. Basically, the problem with wrongful convictions is based on a lack of training, a lack of resources, corruption, and illegal and inadequate legal procedures. These problems exist all over the world. Many reforms have been carried out in the United States at present after all of these cases came to light. For example, we have new police investigation procedures. We have set up units for incorporating convictions into the prosecutor's offices. They are called conviction review units, where the defense and the prosecution work hand in hand to investigate the cases of innocent people in prison and litigating these cases. We have laws that provide more opportunities for submitting cases of innocence. Also in the United States, we have a judicial process available now for declaring a person innocent. This is very important, by the way, because after such a declaration is made, it is then impossible to reconvict in the future or to reopen an investigation in the future, because the person not only is not guilty, the person is in fact innocent, which is not the same thing. We have improved forensic sciences. And in almost all the states of the United States, we now have a remuneration for people who have been wrongfully convicted. For example, in California, we have a law, and people and wrongfully convicted persons receive $150 for every day they were in prison. So this is the compensation we have. Now, in Nicaragua, of course, also has wrongful convictions, just as everyone else does. It's possible, in fact, that Nicaragua has more wrongful convictions than some other countries, because there are so many investigations of problems with the police in Nicaragua, and also we have seen problems with judicial processes. Also, low wage status and poor working conditions among the police create incentives. So this is why in my report to the judges, I draw a comparison of salaries in Nicaragua, and what we find is that they receive very low wages. There's also a problem with judicial independence. Judicial independence in Nicaragua. There are many reports, in fact, about problems with this, with judicial independence. In the instant case, the Caso Puracal case, there are many indicators that this was in fact a wrongful conviction. Number one, the investigation was absolutely inadequate. The forensic science was defective in this case. And also we have problems with opportunities to submit exculpatory evidence to the judge in the trial. Number one, the vapor test. What's the problem with this? The vapor tracer is used for detecting drug molecules of drugs. These vapor tests are notoriously inaccurate. There are studies of this type of vapor tracer device, and the studies have found a 30% to 70% inaccuracy with the use of these tests. So this type of evidence has presented many different types of problems. Why is this? First of all, just like blood tests before we had DNA, there are other causes with this test. There are other causes for giving for positive results besides just drugs. For example, cleansers, detergents. There are many other things that could test positive. We had the same problem with blood tests before, 40 years ago, before we had DNA tests. Another problem is that this is a molecule test. In many cases, molecules can be transferred from one person to another, from one product.
Es muy, muy fácil transpiran en este tipo de casos.
In cases such as these.
Y el derecho a presentar
the right to offer a defense at trial is fundamental. But what happened here? In this case, there was at the trial of Puracal, there was a refusal to allow him to introduce evidence of his innocence, and this has led to wrongful conviction. If he had been allowed to submit evidence, he would have been able to overcome all of the evidence presented by the prosecutor. There was no evidence of drugs except the vapor test, which we have seen is very problematic. And this is another important one. The tests that were done to Mr. Puracal's clothes on the day he was arrested with the vapor tracer found no evidence of drugs at all. But the tests that were performed the next day on his clothing did find the presence of drug molecules. This was after his clothes had been taken to the police office. They could have come into contact with drugs or other evidence in the police station. Also, the bag in which his clothing had been kept had been opened, and his clothing had been handled. So there is a very high likelihood contamination
in this type of process. And the charges for money laundering were refuted by witnesses and by documents. But Mr. Puracal was never allowed to submit this type of evidence. So this is a case that is based on two things, on drugs on the one hand and money laundering on the other. And there was no evidence of either in this case. So, of course, this is a case where the subject is innocent. And well, if you have any question, I likely have answers to them. Thank you very much, Mr. Expert Witness. I will now grant the floor to the representative of the alleged victims so that they may proceed with question. Thank you very much, Mr. President.
For your presentation. As we know, my clients, the Puracal family, are extremely interested in the well-being of the Nicaraguan society. They're very civic-minded. One of their main pushes for this case has been for change, for structural reform. And so I would like to talk more about your explanation of possible reforms in Nicaragua, and perhaps we could start with potential investigative reforms that you would suggest for the Nicaraguan government in light of the Puracal case.
Sure. Well, I think as I outlined in the brief I submitted, that the fundamental problem in the police department we start with is that when you have incredibly low salaries, you don't attract the best candidates. And there's kind of a bad combination in Nicaragua of not attracting the best candidates to the police department, and then they have low salary, which makes it more likely that you're going to have corruption going on in the police force. And then you have poor training on top of that, so that even if you have honest police who are trying to do their best and do a great job, they haven't been trained well on how to do that. And so I think there needs to be a total reform of the police department, starting with the idea of let's get some better candidates in here. And that is not unique to Nicaragua. When you look at studies of police departments around the world, you see the exact same thing occurring. There's corruption in every police force in the world. There's corruption in the police force here in California. But the salaries in California, police officers can make up to $100,000 a year. So they're not as likely to be subjected to corruption, bribes, things like that due to their higher salaries. And then you get better candidates, and then more training occurs. So this is a kind of case where Mr. Puracal should have never been arrested. The protection of the evidence was terrible. The evidence, what was used to test the evidence was terrible. And it's all a result of having kind of low quality employees that don't have appropriate training.
I see, thank you. And maybe we could also discuss possible judicial reforms that would be very important for the Nicaraguan government.
I think you see the same sort of things going on in the judiciary, where, it's when I look at this case, I don't want to speak to the fact of whether a judge is corrupt or just poorly trained, but it's a fundamental principle that of due process, that's sort of a global principle, that when somebody's put on trial, they have an opportunity to present evidence to prove their innocence. And in this case, Mr. Puracal was deprived of the most fundamental trial right there is, which is the right to prove your innocence. And so maybe that's a problem of corruption. Maybe that's a problem of too much integration with the political process and the judiciary. Maybe that's a problem with training of the judges. But we can certainly see a fundamental problem that this case, and I say this about every one of the thousands of cases where we've had exonerations in the United States, that every case has a lesson in it to be learned about how to improve the justice system. And if there's a lesson in this case in terms of the judiciary, it's that people should be entitled to present evidence in their cases, and Mr. Puracal was denied that opportunity.
Yes, definitely. Could you discuss any other possible types of reforms that we could consider here as applied to Nicaragua that would decrease the number of wrongfully convicted individuals in that country?
Sure. I mean, I will try to just highlight a couple because I've written books on this subject and teach 14-week classes on the subject. But first of all, as I've said, you need to attract great candidates to be police officers, to be judges. Political ties should be cut. There should be training on best practices to everyone in the criminal justice system: police, judges, forensic scientists, clerks. Everyone involved in the criminal justice system has to be trained on our best and most modern practices of forensic sciences and investigation. An important thing that I find all over Latin America that's a problem is that there's not evidence preservation laws. We got a law passed in and we, by the way, in the United States didn't have those laws 20 years ago. And we've fought in every state to get laws passed to preserve evidence. And now in California, for example, the government must maintain all evidence as long as a person is incarcerated. And when they're released, they can then destroy the evidence. And the reason that's so fundamentally important is you can't prove innocence in a lot of these cases because there's no evidence to test, because everything has been thrown in a trash can after the trial. So that, I think, is critical in Nicaragua and throughout Latin America. There's major reforms on how to do identifications so that you get the right person. A lot of studies have shown that the way we've been doing them for hundreds of years is not good science. Another simple one that doesn't cost a lot of money is every interrogation should be recorded. Everyone's walking around with a recording device in their pocket. There's no reason to argue that you don't have mandatory recording of statements that are given by defendants so that when you go to court, the court knows the truth of what was said. And those are just a few reforms. There's many more.
That's very helpful. Thank you. And I'm sure that the judges, the Honorable Court, will ask you more questions in that respect. And I'd like to give them plenty of opportunity to ask you questions. So I'll just conclude with one final question for you, because you mentioned compensation laws in the United States. And I would like to turn to that important topic of compensation, if only briefly. How do those work in the United States? What types of amounts are given? How is compensation calculated generally?
So we realized decades ago that it was incredibly difficult for people to sue the government when they got out of prison, even if they were wrongfully convicted. There was all kinds of statute of limitation issues, there's sovereign immunity issues, and very few people were lucky enough to have those lawsuits or could get lawyers to take on those lawsuits. So what we started passing throughout the United States were compensation laws that were much more straightforward. And they basically just said, if someone's been put in prison and they were innocent, then the system failed them. And based upon that failure, the government has a responsibility to compensate them and their family members to help get them back on their feet and to compensate them for the pain and suffering that they've gone through. Every state, because the United States is like 50 different countries, every state has a different law in regards to this. As I said earlier, in California, you receive $150 a day for every day you're incarcerated. So I've had clients in prison for 20, 30 years. My clients who've been in for 20 years get around $1 million from the state for their wrongful incarceration. The processes are a little different everywhere, but it's basically the same concept. You were proven innocent, a judge said you were innocent, and now we're going to compensate you through the state government. And so some of the laws are better than others, but they all have the same basic idea.
And finally, you found in this case, right, that there hasn't been any explicit declaration of innocence, right, when we're looking at Jason's judicial process. I mean, there was an annulment, but nothing more. What could Nicaragua do in this particular case to sort of clarify to society that he was innocent?
Yeah, so this is a complicated legal issue that I've dealt with my entire career. I'll go to court and I'll get my client's conviction reversed. And I've been lucky that I've been part of 40 exonerations. I've been able to personally be involved in cases where 40 of my clients were freed and found to be innocent. And I'll walk out of court and the reporters always ask the same question. They say, well, your client wasn't found innocent. The court just reversed the conviction. And I'll say, well, my client's as innocent as you are of this crime, or I am of this crime, because they're no longer under threat of it. But the reality is they are under threat. They just have no longer convicted. And so what a declaration of innocence does is it takes that threat away and makes clear, no, this isn't a case where there just wasn't enough evidence to prove this person guilty. There wasn't enough evidence to prove beyond a reasonable doubt guilt. There's actually proactive evidence of innocence, and therefore the court should declare them innocent. And Jason's case is one of those cases there where you're saying Jason was convicted of nothing based on nothing because the evidence that was presented against him is so deeply faulty, and because he was never given an opportunity to even defend himself, that it's appropriate for the court to actually declare him innocent so that there won't be further proceedings, that this case has finality. And in some jurisdictions in the United States, they require that declaration of innocence in order to receive compensation. And so it's an additional thing that judges just rule on after we have these habeas hearings. We come in, the judge says the conviction isn't sound, the conviction is reversed, and then we ask the court to recognize our client's innocence, and the court gives a declaration of innocence. And then with that, our clients are automatically compensated by the state government because there's a judicial record that this is an innocent person who's been incarcerated. And it's a great procedure. I mean, I'm not one of these people who thinks the United States does everything the best way, but one area we have spent a lot of time on is this post-conviction exonerations, because we've been using DNA in our trial courts since the mid-90s. And there's a lot that we've learned through all these exonerating cases.
Thank you very much. It is definitely our hope that the Honorable Court takes a step forward in its jurisprudence and actually declares the innocence of Mr. Jason Puracal. And it, of course, is also our hope that the appropriate Nicaraguan authorities and courts will do the same eventually. Señor Presidente, ya terminé mis preguntas. Muchas gracias.
Muchas gracias, señor representante. Y al señor perito también.
Thank you
muchas
to the
gracias.
representative of the alleged victims and to the expert. I now ask the judges of the court if they wish to ask any questions. Judge Diego Moreno Rodriguez, do you wish to ask any questions? Yes, thank you very much, Mr. President.
First of all, Professor Brooks, welcome and thank you very much for your time and for being here this morning. I understand it must be very early for you in San Diego, so thanks for being here. It's an honor. I read your dictamen pericial very carefully. I also took some interest in your book, You Might Go to Prison. And I want to start by asking, you make an affirmation regarding the political context in the country affected, in this case, Nicaragua, stating that basically the executive branch has managed to take control over all the other branches of government. So if you start from this premise, then my question is, how does this political context bear on any reforms that this court might order regarding judicial training or better salaries for policemen? How does the context come into bear with these reforms, some of the reforms that you discuss here?
Yeah, that's a tremendous question, because that is a tremendous challenge. You know, how do you encourage a government to have the kind of reforms if they actually more want to maintain control over the judiciary or control over the police force? All I can say that even after decades of doing this work, I've fought against being cynical that change can't occur within any type of regime. I do think that is a tremendous challenge. I think the more these things are brought out into the light, the more likely those kinds of reforms will happen. That's why I think it's great that the Puracal family have brought this claim and have been very public about it. A lot of people that go through what Mr. Puracal has gone through just want to go on with their life and never think about this stuff again because they've been through so much trauma. But I think this case can make an important statement. And I still believe that there are good people in Nicaragua who want to do the right thing, and police officers that want to do their job, and judges who want to do their job well. And I think by talking about wrongful convictions and how they occur, I think changes can come. But you are right, it is a huge barrier to entry to get big resources towards, hey, let's make the police better trained, let's give them more money, let's do a better job of all this. I think there is a breaking point at a certain point where public safety becomes such an issue that you do have to increase the quality of your police force and their training in other aspects. And this kind of comes with it, that they'll also be better at investigation if they're also better at, you know, all the other things that law enforcement is supposed to do.
Okay. And moving forward to another question, what happened during the proceedings exactly? Why wasn't Mr. Puracal allowed to produce this evidence that you mentioned could have cleared him of all charges that were pressed against him? What happened? What did the judge do exactly?
So my understanding is that Mr. Puracal had detailed records that would counter the claim that he was money laundering. You know, he's working for a real estate company, an American real estate company, Remax, and had a lot of paperwork to do with, you know, a real estate company is transferring funds regularly through deposits that people are making and payments for their purchase of homes. And that was what was alleged to be money laundering. And I think if Mr. Puracal had been able to introduce the records to show it's a legitimate business and not money laundering, that would have countered the total lack of evidence that there was money laundering. And in the same way, there was no evidence of drugs. I mean, in the United States, having vapor tracer evidence of drugs is not sufficient for a drug conviction. You don't actually have drugs, you have molecules that have been tested upon something. And the idea that that's a drug case is absurd. It's not a drug case. So in my mind, it's not a drug case because they didn't have evidence of drugs that would be sufficient for a drug case. And it's not a money laundering case because they had no evidence of money laundering. And on top of that, Mr. Puracal had evidence specifically that there wasn't money laundering. And that's why I think this is an appropriate case for a declaration of actual innocence, because he had proactive evidence of his innocence and the government didn't have any evidence of his guilt.
Thank you. Thank you very much. A next question. You have a lot of experience in this, 40 years, I believe you mentioned you've been working on cases such as this. What can you tell us about some of the types of personal, family, and social damages that you found that the victims of wrongful conviction face? Can you elaborate a little bit about that?
Sure. Thank you for that question. So, I mean, being wrongfully convicted is a surrealistic nightmare. I get asked all the time by reporters, what's it like being, in prison and innocent? And I say, I have no idea. I've never spent a night in jail, but I've spent a lot of time with people who have gone through that. And if you're guilty in prison, I think you can kind of come to peace with it at a certain point and say, I committed a crime and now I'm in prison for it and I'm going to do my time. But if you're innocent in prison, you're waking up every day in a kind of a surrealistic nightmare of, I'm not supposed to be here. So first of all, they do much more difficult time than other people in prison, constantly struggling to get out, constantly feeling like the whole world is just turned upside down. On top of it, obviously, Jason went through some unique things in his case with the conditions in La Modelo and all the stuff that he dealt with. But there's universal psychological damage to everybody who's gone through what he went through. Every single one of my clients has suffered from PTSD. Every single one of them, when they get out, struggles to get their lives back together. They can't deal with technology. They have trouble working. Their relationships with their families have been fractured. They have trouble getting back into being parents and being partners. With every one of my clients, I've gotten them into therapy, and most of them spend years in psychotherapy just to get back to being normal. It's an incredible stress on the families, on themselves. And the damage is something, there's only one person on this call, honestly, that understands it, and that's Mr. Puracal. And then his family understands what they went through in relation to that and the desperation that a family feels when they can't do anything to get their loved one out of prison. I literally had to get security at my office because parents would show up when I first started this work every day with all their boxes and saying, please, I'm begging you, take on this case. My son's in prison, my daughter's in prison. And you'd see that desperation of those family members, and it just wrecked the families because they could never, just like the person in prison, they could never reconcile, why is my son in there? Why is my daughter in there? And it just changes your whole view of the world. And I've seen that devastation time and time again.
So this is a follow-up question. As you may be aware, this court has a power to issue reparations toward the victims, aside from the structural reparations that it made order. But when we talk about the victims, the alleged victims in this case, in your experience, what concrete reparations have proven or could be more effective in order to bring justice to persons who have been wrongfully convicted? What would be more effective in terms of reparating all these damages that you have explained to the court that they suffer?
It's obviously we can never truly repair what's happened to them. So, the financial is just sort of, well, this is what we can do. We can give money. And money can be used to make your life a little better and help you get the therapy you need and help your family be in a better situation than, economically, because we've also obviously taken away economic opportunities from you by putting you in prison. You lose years of working and all of that. I've had some interesting, I've had some cases in California where prosecutors have agreed my client's innocent, and my clients have received compensation, but also have received on top of that the state paying for their therapy, the state paying for their education, other things that are more holistic to help get their life back on track. Helping them getting their social security number, helping them getting their driver's license back. There's all kinds of, I've had older clients that don't get Medicaid because they were in prison when they were supposed to apply for it. So there are some more holistic things that can be done. But in general, mostly what the legal system can do for its victims is compensate them. And I listened to the testimony yesterday, and it's, heartbreaking hearing Mr. Puracal's wife and thinking about what she went through all of this, and hearing from his sister and what she went through. And I know their mother went through a lot. It's not just one person who's affected. There's a circle of pain around everyone who's wrongfully convicted.
Thank you, Professor. Just one final question, because I want to give the chance to my colleagues to I'm sure they also have questions, but I found this very, very compelling, very interesting what you mentioned about this special procedure for having a court declare a person you're innocent. You're cleared of all charges, you're innocent. But and you're the expert here, so this is the reason I'm asking the question. Is there a risk that maybe someone who has already faced the judicial system and that has been wrongfully convicted, with all the trauma that brings about to the person, that they may not even want to go through a new process, whatever the goals of that process may be, and what happens if things go wrong in that process? What happens if the judge doesn't issue a ruling in the sense requested regarding the declaration of innocence? I wonder if you have any thoughts to my reaction to your proposal here.
That is a very high level question, because I have dealt with that and we've struggled with that in some of our cases. I've had clients who are filing lawsuits against the government, and then we think, well, if we go ask for a declaration of innocence, that judge is the kind of judge who's going to deny it. And now how is that going to impact a civil suit? And then we've opted just to go through the civil process and prove innocence there and win the civil suit. And that's a question lawyers face in these kinds of cases. But the reality is very few people have an opportunity for a civil suit, even in the United States, within a state, let alone going to another country to sue a country for it. And so I think the Declaration of Innocence is a very important process. But yeah, you're right. Down the road, lawyers could struggle with that, and clients could struggle with whether they want to go through the process at all or whether they just want to let it go. And that's why I think it's so great that this case has been brought, because a lot of people in Mr. Puracal's situation would have done exactly that. Just said, I'm living in the United States. I'm not going back to Nicaragua. I'm done with this. And this brings this issue to light.
Thank you very much, Professor. You've been very kind. I have no further questions, Mr. President.
Muchas gracias, juez Diego Moreno. Yo pregunto ahora, juez Alberto Borea.
Thank you, Judge Diego Moreno. Judge Borea, do you have any questions? Yes, Mr. President, thank you. Thank you, Professor Brooks, for your presentation and for the ideas that you have shared with us, not only on this case, but also on the general debate concerning an issue that needs answers. You're saying that if there's no evidence in a case, or at least no reasonable evidence in a case, or minimally sufficient evidence in a case to begin a process against a person, according to what you have been saying, this is when we ask not only that the person be declared not guilty, but declared innocent. So my question is this: would that not imply that there is there is a need for a new trial,
contra esta persona que
a new
actualmente,
trial against this person.
¿cómo vería, a quién vería usted
And
haciendo ese juicio o llevando adelante
and who would
ese
be
juicio?
doing that trial? Who would carry out that trial?
Bueno, en los Estados Unidos no es exactamente
In the
un
United
juicio
States, it's not
nuevo por
exactly a new
proceso de
trial
una declaración de inocencia.
for a
Es
declaration of
después de
innocence.
todo el
It's
proceso de
it's
habeas
after the
corpus
whole process of
y
habeas
el juez tiene
corpus,
toda la
and
información.
the judge has all
A
the
veces
information at
cuando hay
that point.
más
Sometimes
información
when
que
there
no
is
fue
more
importante
information
durante el
available that was
proceso
not
de
seriously
habeas
considered during
corpus
the
que
habeas corpus
nosotros
procedure
introducimos.
that we introduce.
Pero para mí estos
In
procesos
my view, these
implican como 1 o
processes
2 horas
entail
del tiempo
could take 1 or 2
para el
hours of
juez
time for
y
the
no más que
judge,
eso, si yo
and no
entiendo la
more,
pregunta.
if I understood your question correctly.
No sé si me he dejado entender yo
I don't
bien,
know
pero en
whether I
fin,
expressed
más o
myself
menos va
well,
en
but
la
in any
línea.
case,
El tema
it's
es,
along the same basic lines.
el tema es el
The whole
siguiente.
matter here is this:
¿Quién juzga?
who
Who's going to judge the new
Okay,
things
¿quién?
that is going to arise when you have decided that it was a fraud, the entire process?
Yes, that is a good, thank you. Well, you know, sometimes in our habeas process in the United States, you typically go back in front of the original trial judge to get a conviction reversed. Now, if you have evidence that that judge is biased against your client or has done something really bad in the case, kind of like this case, then you can request a change of judge. Also, if you lose that, you can petition the Court of Appeal to reverse that decision from the trial court. If you lose in the Court of Appeal, you can go to the state Supreme Court. So there's always an additional process, but you're correct. There is a problem of going back often to the original trial judge and asking that judge to say your client's innocent after that judge said your client was guilty.
Mhm.
And that is another hurdle in this process.
Okay. Other questions. What happened in the United States and in your experience? What could happen with that people that uses the procedure an unfair way and with impunity, because there are a lot of prosecutors that they decide to go on with the procedure, notwithstanding that they do not have an absolute evidence, or even worse, when they hide the proof to the defense in order to not to get the weapons to become declared innocent.
Mhm.
What is the punishment, or what's the way to stop this kind of behavior?
It absolutely happens. You're correct, Your Honor, that this is something that we deal with in every jurisdiction in the world, that when you have bad actors, when you have bad prosecutors who will hide evidence, when you have bad police officers who will falsify testimony, it is very, very difficult to do anything about that. And I would say that the United States has not done a very good job with that. In the last couple of years, we did incarcerate one judge in Texas, but it's pretty rare that a judge would ever be punished for anything in our system. And judges and prosecutors have total immunity against any civil suits. They cannot be sued in the United States. So we can, if you look at the thousands of exonerations, very few of them have been when you're dealing with really serious corruption. Most of them have been just people doing a bad job, and people being negligent, people being lazy, and later on showing that the person should have not been convicted. But we do have now, like I said earlier, we have what are called conviction review units, where they assign prosecutors within offices to go back and look at work from the past and find the cases where mistakes was made. And some of those have led to prosecutors being fired, to situations where lawyers are disciplined. In the United States, we have a bar association that every lawyer pays about $500 a year to, and that has investigators that will go out and investigate if there's a report to them that lawyers have done unethical things. And so there are some different resources that we utilize, but I don't pretend that we do a great job of that. And I think the thousands of people we've freed, it's hard to say they're lucky, but they are the lucky ones because there's a lot more people in prison that we just can't prove their innocence, even though they are innocent, because we can't get the evidence.
Well, that's a problem for the entire world. Okay. Thank you very much for your testimony and for your knowledge, Professor Brooks.
My pleasure. Thank you.
No más preguntas, presidente.
Muchas gracias, juez Borea. Me pregunta a jueza Patricia Pérez si desea
Borea.
formular alguna pregunta.
Judge Patricia Perez, would you wish to ask a question? Yes,
Good morning, Professor Brooks.
President, I will.
We really appreciate your insightful presentation. I just have two brief questions. On the basis of your experience and your study of the case, which was the evidence used to convict Mr. Puracal apart from the vapor tracer?
Well, the vapor tracer, as far as I know, is the only evidence of drugs. And like I said earlier, I don't think that is evidence of drugs. It's evidence of molecules of drugs that could have come from anywhere. And in terms of the money laundering, I do not know of what evidence was when you look at the elements of what you need to prove for money laundering, meaning that there was illegal funds that were received that then were processed in a way to clean up that money. As far as I've seen, there's no evidence of that. And that's why this looks like a case to me where there was no evidence at all of either charge.
Okay. And the second question regards to what you said about the impossibility of Mr. Puracal to prove his innocence. Was that impossibility due to a legal provision in Nicaragua, or it was due to a lack of diligence of the defense, in your opinion?
As far as I know, it was the judge denying him to introduce the documents and the witnesses that he had that could have proven how that money was brought into the company, what it was used for, how it was transferred, and he was just denied that opportunity to defend himself.
And yes, I understand, but do you know if that decision of the judge was based on a legal provision or was just a particular decision of that particular judge?
I believe it was a decision of that particular judge, but I'm not an expert on Nicaraguan evidence rules. I know something, in a lot of places in Latin America, it's very open in terms of what the judges let in and don't let in. I've worked extensively in Chile and Mexico, and neither had an evidence code. So when you don't have an evidence code, it's hard to say you did it for any particular reason and cite a law for it. It's just more the judge's discretion.
Well, yes, but anyway, you have to have some kind of standards. For example, in Chile, you have standards on the basis of which the judges adopt those decisions. So that's what my question was regarding if you knew if there was a particular provision in the Nicaraguan legal system, but I'm fine with your answer.
I think it was just a relevance, the usual relevant stuff. And by the way, when I speak of Chile, I was down in Chile 25 years ago, just after Pinochet training the first public defenders. And I know at that point, there was no evidence code, but I know since then, the Chilean system has become one of the best systems in Latin America as all the reforms went through. But evidence is a different concept in different countries. And so my understanding is probably, and I'm speculating a little bit here, that it was based on the judge believing it wasn't relevant and therefore not introducing it.
Thank you. And one last question. Yesterday, Mr. Puracal told us that in his opinion, on the basis of what he had lived, darkness allows injustice to survive. So in your experience, how would you say that this remark plays into all this situation that you have had the opportunity to study in this case, particularly in the Puracal case?
So could you give me the quote again? Darkness?
He said, darkness, referring to all the procedure, not only the judicial procedure, but also he his time in prison. He said, darkness allows injustice to survive. So in your opinion, on the basis of your experience, does this make sense to you, and in what way?
I mean, I think that's what my whole career has really been based on, so I couldn't agree more with them about it. I think the whole reason we've had what we now call the innocence movement, which it's been a combination of lawyers bringing cases, the media covering those cases. Now we see, Netflix doing, shows about innocent people in prison. And if I think, 30 years ago, people would argue with me about whether there were innocent people in prison. Now that we've documented thousands of these cases, the question is now how and why and what can we do about it? But it's only because all those cases have been brought to light, like this case, that we see reform happen and changes. And reform also only happens when it's connected to real people and real stories, because nobody really cares about legislation in the abstract. They only care about it at the human level. And so I think, that bringing light to every one of these stories, and every one of them is important, everyone we can learn from. And, transparency is so critical to a justice system.
Thank you very much, Professor Brooke. No tengo más preguntas, presidente. Muchas gracias.
Muchas gracias, Jueza Pérez. Le pregunta ahora a la jueza
Thank you,
Gómez.
Judge Perez. I'll now ask Judge Gomez, do you wish to ask a question? Yes, Mr. President.
Thank you for your report, Professor Brooks. I know this is an unfair question, but do you think this is a case of error or fraud? Dolo.
This case looks so bad to me that I think it's a case of fraud, to be honest. I mean, I see mistakes all the time, and my students always immediately jump to every cop is corrupt, every judge is corrupt, and and I still firmly believe that most people in the criminal justice system get up every morning and try to do the best they can. And so I see a lot of cases that are just mistakes, people not noticing things. But this case is so bad that it's hard to believe that this case isn't totally fraudulent.
Mm-hmm. Thank you for your candor. This decision, I know you've been asked this before by my colleagues, but this decision of the appeals court, that is a decision on retrial, isn't it? How frequent is in your experience that you would have a decision on retrial and then a deportation? Why do you think that this happened in this case? I mean, of course, this was very fortunate for Mr. Puracal, but how do we make sense of this?
I mean, one way to make sense of it is not having to admit anyone was wrong, and then you deport, so there's not going to be a trial, and then it just goes away. Nobody thinks about it again.
Or is somebody cleaning up, let's say?
Yeah, I had a death penalty case in Qatar where my clients were charged with killing their daughter. And it was basically a case totally based on racism. There was no evidence. And by the time the judge looked at it, everybody was embarrassed by this racist police officer who brought this charge. And so it was a death penalty trial. In the middle of the trial, the judge just released my clients and told them just to show up in court the next day in the middle of a death penalty trial. It was basically the judge, everybody wanted them to just leave the country, and then they could all just forget about it because it was so embarrassing, and everyone realized it was a bad case. My clients stuck around, and we proved them innocent and then got them home to the United States. But I see that kind of face-saving stuff all the time. Sometimes prosecutors I'll have in California will prove our client innocent, and then they'll recharge them, and then they'll say, we'll give you time served if your client pleads guilty. And so I have to go back in the jail and tell my client, they're re-prosecuting you. You're going to be in jail for at least a year waiting for the trial. I think we're going to win, but I can't guarantee that. Or you can go home today, but you got to plead guilty. And it's a game of saving face by not admitting they're wrong. And this looks like that kind of thing in this case as well.
I see. Thank you. What about these cases in a context of diminished judicial independence? You know, a case like this, but with a context. Can you contextualize it in Nicaragua, in your experience?
In my experience in Latin America, my parents moved to Puerto Rico when I was 12 years old and dropped me into high school. I was the only gringo in my high school. So in my long experience of just in general in Latin America, there's a lot more attachment of government to politics and to political parties. I think we're getting more like that in the United States, unfortunately. But that kind of connection hasn't traditionally been what we have, that judges are part of political parties, that the judiciary is attached to politics. And so my only comment I can make on that is that that creates these kinds of political problems when judges don't have independence to make decisions. And when you get cases that sometimes it's worse when they're high profile cases, which is, to be honest, I always tell people in Latin America, do not go to the media, do not make a lot of noise about this case. You're going to make it a lot harder on yourself because now people are going to have to prove you're guilty or stick to the case. And so it just becomes when politics invade the judiciary, it's never good. And I guess that's just my general statement about it without anything specific, because I don't know exactly what happened with this judge, who this judge specifically was answering to or not answering to, whether it was incompetence or corruption or both.
And the last one, what is the role of international protection on this?
Well, I, as I'm sure everybody here, is a tremendous believer in international law and the power of international human rights law to make change within countries. I know sometimes it feels futile, which is why I thank you all for your service. It's a difficult thing when you're trying to get countries to change their policies from outside those countries or from extrajudiciary bodies that they don't necessarily recognize. I know sometimes you have that problem with the United States for sure. But it's an important task to keep making as much noise and keep talking about things. And I believe, like Martin Luther King, that the arc of justice is long, but bends towards justice. So some of these cases might feel futile, but I think in the collective,
I'm sure we all agree, but more specifically, on the one hand, you know, it's the courts that the local courts that have the ability to respond to evidence that there's been a an issue with evidence. But how do we connect here the interpretation of the American Convention on Human Rights to what is happening in the particular case? This is a very special circumstance because the alleged victim has been released already.
I think because this case deals with such a fundamental universal right. I mean, you could talk all day about whether the forensics are accurate, whether they should use vapor tracer and things like that, but that's such a narrow issue. Maybe that doesn't carry a lot of weight that you have a poorly trained officers, poorly trained judges. But the opportunity to present a defense is so fundamental in justice systems throughout the world. It just seems like this is such an important case to make a statement on that. And can that guarantee a response that's going to change a system? But that is so fundamental. It just seems like it's hard to deny listening to that.
Thank you very much. No tengo más preguntas, señor presidente.
Gracias, Jueza Gómez.
The questions. So thank you, Judge Gomez. Judge Perez Manrique, do you have any questions? Yes. Yes. Good morning, Mr. Expert Witness. My question is very specific. Yesterday, the sister of Mr. Puracal, who is herself an attorney, said that the government of Nicaragua had power over everything, including over the courts, and that therefore you could not trust the system in Nicaragua. In this particular process, we have a situation where the state of Nicaragua has not the court, and so we cannot hear their perspective on this case. We can't hear their voice. And the same thing is true for another process at this point. So I wanted to a bit of follow up on some of the questions that my colleagues posed. I would like to ask you how, by handing down a judgment, this court can change the situation. How do you see the scenario in which this court that this court is facing in this case?
So again, if the question is, and maybe someone could translate it for me a little bit so I understand, it's a specific question of, again, what this court can say in terms of what to do with Mr. Puracal's sentence?
Taking into consideration the case of Nicaragua, that's the question.
In the case of I'm sorry, I didn't understand that.
If you take into consideration the case of Nicaragua, which kind of ruling could this court do in order to avoid cases like that to repeat again?
I mean, I guess, again, all I can say is I don't know if this will be effective, but I guess, I would have personally never gotten into the work that I do if I thought I was going to win all the time. I'm sure the judges here agree with that in terms of your jobs as well. I don't know if this will have an impact, but I think it's so compelling that it's worth doing. And I think the more of these cases that come up and the more voices that are said and the more times we call out these injustices, the more likely there is going to be some change. I don't expect it to happen overnight, but this is such a gross example of a fundamental violation of due process that I have to believe that somebody's going to hear that.
Bien. En el plano de los múltiples factores.
When we look at all the factors that you have described, the factors that can lead to wrongful convictions and wrongful sentencing, you made reference to your experience in your own country and the use of the habeas corpus as a remedy that makes it possible to review a wrongful conviction. Thinking in more general terms, I would ask whether you could help us by explaining what procedural requirements would need to be met by a procedure in order to make it possible to review a wrongful conviction. What remedies would need to be available? In many countries, the possibility of reviewing a case when res judicata has already gone into in order to review a conviction based on res judicata. Sometimes the timetables, procedural timetables, are too narrow for requesting an appeal of this kind. So in general terms, even beyond the United States, what elements should be included in a procedural system to make it possible to review a judgment of this kind?
So in the 40 years I've been doing this kind of litigation, there's only been 4 claims that I can make in the United States in order to reopen an old case. And the 4 claims are: number 1, I have new compelling evidence of innocence. Number 2, false evidence was introduced at trial, which means my client didn't get a fair trial. Number 3, there's been what we call a Brady violation in the United States, meaning that the government withheld evidence that could have proven my client innocent. And number 4, that my client didn't receive competent counsel. Therefore, it's a violation of their Sixth Amendment right to a competent lawyer. And those are the only 4 claims that ever can be brought up in a habeas innocence case in the United States. And we can bring those up in state court, and we can bring them up in federal court. And if you lose in state court, because those are constitutional principles, you can then appeal into the federal courts. So basically, how our habeas works is I get a letter from somebody who's been in prison for a long time, and then we investigate it. And if we can find really compelling new evidence, like DNA testing that shows they're innocent, we can file a claim. If we can prove that some false evidence was introduced into the trial, we can make a claim. If we can prove, which is the most difficult usually, that the government withheld evidence, we can make a claim. And if they got a really bad lawyer, we can make a claim because those are all protected by the Constitution. And again, I don't think the United States necessarily has a corner on good procedures. I'm in the UK right now, and in the UK they have a conviction review board. That's a national board that is given the assignment to review cases of people who are wrongfully convicted. And if they make that determination, then the cases get sent out to judges to reverse those convictions. But every country should have some process that allows people to bring these claims after they've been convicted, because we now know that there are a lot of people who get wrongfully convicted, and if there's no procedure, then they just, die in prison.
Justamente, señor Perito, a eso era mi pregunta. ¿Qué elementos, usted me dijo cuáles eran las en función de los cuales en Estados
the 4
Unidos
points in the United States,
realizar una
but
condena?
for
Yo le digo,
for revision of a conviction. If we look at this in general terms, what should be the minimum factors of a remedy that would make it possible to revise a wrongful conviction? We're thinking here in general terms, applicable to Latin America specifically, which is where our jurisdiction lies.
So the minimum standard that we apply is you basically write a petition to the court and say, I have this evidence, and if this evidence had been heard at the time of trial, the person would not have been convicted. And that's the standard that's applied. Now, there's still obviously a lot of discretion in that. Judges could differ. One judge might look at it and think, I think they still would have been convicted, even with this evidence. Other judges might think, no, I don't think they would have been convicted. DNA changed everything in this work, because before DNA, we didn't have sort of 100% proof. This person definitely didn't commit this rape. This person definitely didn't commit this murder. Here's DNA that proves it. And so a large number of the exonerations involved DNA, but that kind of opened a door that judges started thinking, oh, well, if we're making mistakes in the rape and murder cases, maybe there's mistakes in the robbery cases, maybe there's mistakes in the drug cases. And then we started seeing it open up and have a lot more people who were freed from prison. But yeah, that's the basic process. And most of those petitions get denied. The judge looks at it and says, I don't think so. But you have an opportunity to present the evidence you have. And then if the judge thinks they want to have a hearing, they grant a hearing. And then the lawyers come in and we argue about it. And then the judge has the power to reverse the conviction if the judge believes that the evidence is compelling, again, of one of those 4 things: that there's strong new evidence, that false evidence was introduced, that the government withheld evidence, or that you had a really bad lawyer. With any one of those, you can get a conviction reversed.
Muchas gracias, señor Perito. No tengo
Thank
más
you,
preguntas.
Mr. Expert Witness. I have no further questions, Mr. President.
Gracias, juez Pérez
Thank
Marín.
you, Judge
Thank you very
Perez.
much, Mr. Brooks. If you wish, you can keep on following the audience. Thank you very much.
Thank you.
Daré ahora la palabra a la representación
I will now recognize the representatives of the alleged victims to submit their closing arguments. Please tell the court who will present the arguments. Thank you, Mr. President. I am Thomas Ankoviak from Seattle University School of Law. My closing arguments will be brief and concise. As we have demonstrated in the processes of this court and the Inter-American Commission, Mr. Jason Puracal, citizen of the United States, was illegally arrested and held in a Nicaraguan prison where he experienced inhuman conditions from the time he was arrested on November 11th, 2010, up until he was released on September 14th, 2012. Mr. Puracal was sentenced to 22 years of prison after processes that were littered with serious mistakes, in which the judge was not authorized to serve as an attorney, where false evidence was submitted and where he was not allowed to present any defense whatsoever. His appeal, his petition for appeal was denied by Nicaraguan authorities, and Mr. Puracal experienced shocking conditions in the maximum security prison of Nicaragua, known as La Modelo, despite the fact that he was absolutely innocent of all the charges against him. Mr. Puracal was ultimately released after a judgment by the Court of Appeals that overturned his conviction, but did not exonerate him or recognize his innocence. Immediately following that, Mr. Puracal was arbitrarily deported from the country, and the Office of the Public Prosecutor appealed the decision overturning the conviction. The violations by the state have divided the family between two countries, as we heard, and have caused many types of serious difficulties for them. Moreover, the state has not indemnified Mr. Puracal or his family for all their suffering. It has not declared their innocence. It has not returned any of the assets that the state had illegally seized. Of course, since 2018, the human rights crisis in Nicaragua has been recognized worldwide. However, the authoritarian methods that the Ortega regime had started to use much earlier, even before the facts of the instant case. From the early years of Daniel Ortega's second term of office, which began in 2007, a number of international institutions, such as the United Nations and the Inter-American Commission, had recognized the serious problems in Nicaragua for protecting human rights.
The violations suffered by Mr. Puracal and his family are actually part of a clear pattern involving arbitrary detention, abuse of pretrial detention, inhuman conditions of detention in notorious facilities such as El Chipote and La Modelo, and violations of the adversarial process. Now, considering all of our evidence, testimonies, and arguments presented before the Honorable Court and the Inter-American Commission throughout this process, which began in 2013, it has been fully proven that, first of all, the state of Nicaragua has violated Mr. Puracal's rights enshrined in Articles 5.1, 5.2, 5.4, and 5.6 of the American Convention on Human Rights, as well as those enshrined in Articles 1, 6, and 8 of the Inter-American Convention to Prevent and Punish Torture. That Nicaragua violated Article 5.1 in relation to Article 1.1 of the Convention regarding Ms. Scarlett Flores, Jabu and Jazz Puracal, Ms. Puracal, Janice Puracal, Ms. Daisy Zacarias, the mother of Jason, and Ms. Jamie Puracal, the sister of Jason. The state has also violated Mr. Puracal's rights enshrined in Articles 7.1, 7.2, 7.3, 7.4, 7.5, and 7.6 of the American Convention in relation to Articles 1 and 2 of the very same instrument. Article 7.2 was also violated in relation to Dr. Daisy Zacarias, Ms. Scarlett Flores, and her son Jabu, who were illegally detained in their home for approximately 6 hours while the police were searching the premises without a warrant. Nicaragua also violated Article 8.1 and subparagraph C, D, F, and H of Article 8.2 of the American Convention, all in relation to Article 1.1 of that treaty with regards to Mr. Puracal. the state has violated Article 11 of the convention in relation to Article 1.1 with regards to Mr. Puracal and his wife, Scarlett Flores, that the state violated Mr. Jason Puracal's right to property under Article 21 of the convention, that the state has violated Article 22 of the convention in relation to Article 1.1, as well as Articles 11.2 and 17.1 with regards to Mr. Puracal, Ms. Flores, and their 2 children. Nicaragua has also violated Articles 8 and 25 of the convention with respect to Mr. Puracal. And finally, the state violated Article 19 of the American Convention in relation to Article 1.1 with respect to Jabu and Jas Puracal, the children of the couple. Now, with regards to reparations, one of the aspects that I most admire about the Puracal family is their commitment to structural reform in Nicaragua. As you have heard, they don't want others to suffer the same injustices that they endured. In fact, Jason and Scarlett hope to one day return to Nicaragua, a country that they loved, once the rule of law has been restored, once they are able to return with their children in safe conditions. We hope that that day will indeed come, but for that to be possible, as the judges of the honorable courts themselves have said, Nicaragua must carry out numerous legal and institutional reforms, as also emphasized by our expert witness, Professor Justin Brooks. Specifically, we request that the court order the following measures, all of which have many precedents in the Inter-American Court's case law. We respectfully request that these measures be very specific in the court's judgment. This because, as we all know, the current Nicaraguan government, with its record of ignoring the decisions of this honorable court and other international authorities, will seek to evade the orders of reparation, particularly those lacking the sufficient level of detail. Therefore, we request that this honorable court ordered the state of Nicaragua in clear and precise terms to adopt the following measures of reparation. Reform its judicial procedures so that they are consistent with its own legal code and the American Convention. Remove all political obstacles that prevent proper investigation of the facts, implement training and education on matters like due process in criminal proceedings for the country's prosecutors, allow human rights organizations and independent human rights organizations to monitor and observe judicial procedures as well as criminal investigations, so as to uphold judicial guarantees and due process in the country. Adopt legislative, administrative, and economic measures to comply with the minimum rules for the treatment of prisoners, as explained in the brief that we submitted to the court. Issue a public apology to Mr. Puracal and his families for the events. Publish the facts and the court's decision in national newspapers, on TV, and on state websites. Cease to use vapor tracer technology, or at the very least, establish a training program for the police and the judges on its proper use. Investigate and prosecute all of the parties responsible in this case, police officers, prosecutors, prison officials, and judges, for the crimes and human rights violations involved in this case. Assist the Puracal family in establishing the Innocence Project, as we explained in our report before the court. It's important to also expunge Mr. Puracal's criminal record and remove his name and Scarlett Flores' name from any criminal file in Nicaragua. Guarantee the conditions for freedom of movement and residence so that Mr. Puracal and his family can return safely and with dignity whenever they choose to do so. And finally, I would like to address the matter of monetary compensation. Now that you have heard from Jason, Scarlett, and Janice, you will understand that they have fought this for nearly 15 years for one reason and one reason alone: justice and official acknowledgement of everything that they have endured. Justice defined as the recognition of human rights violations and fair reparation, including those structural reforms for society as we discussed them. Money was never the goal. And how could it be in a case against the current Nicaraguan regime? Nevertheless, we must all recognize the devastating economic impact that these events had on the Puracal family. Jason had become a successful real estate entrepreneur, and all of that was taken from him. All of his income and all of his investments, which added up to nearly $498,000, he lost them. And then his franchise was canceled, and he was also deported directly, which obviously prevented him from continuing his successful career in Nicaragua, and which led him to lose everything that he had worked so hard to achieve in that country. So, regarding this point, must be emphasized that the state of Nicaragua has made it extremely difficult to prove the extensive economic damage, because the police entered Mr. Puracal's office and they seized all of his computers, hard drives, etc., and the state has yet to return anything to the state. Additionally, we attempted to present an expert witness, a real estate agent from the very same market in Nicaragua, who could have offered detailed insight into Mr. Puracal's economic damages. However, the agent had a well-founded fear of revealing their identity or appearing publicly at this hearing. This is clearly understandable because they could have easily become another victim of the Nicaraguan regime, just like Jason Puracal was. We request that the court accept this expert information and keep the person's identity confidential. But of course, our request was denied. So with the utmost respect, we hope that the court will take into account the state's obstruction and persecution, as well as our persistent efforts to demonstrate these significant economic damages, also supported through our evidence and victim testimony, etc., when ordering compensation for damages. Now, Ms. Scarlett Flores' life project was also cruelly cut short. As we have heard, Mrs. Flores was clearly on track to obtain a job as an attorney and potential incredible entrepreneurial success because of her intellectual capacity, charisma, and her social skills. She was just about to finish her studies and to be sworn in as an attorney in Nicaragua. However, due to her husband's arrest, Ms. Flores was never able to finish. Due to Jason's arrest, she lost her internship at the public prosecutor's office, and then they had to go into exile, and her legal career, like her whole life in the country, was abruptly ended. And finally, Janice and the Puracal family as a whole spent all of their savings and much more. We're talking about a sum of around $750,000 to rescue him from arbitrary detention. Mr. Puracal and his family incurred in legal fees, investigator fees, and among other things. The family also incurred expenses for traveling several times from Nicaragua, from Washington, D.C. to advocate for his release. The costs and expenses incurred in the case were reasonable and necessary given the extreme conditions of his detention and also the difficulties in the political framework of Nicaragua. As explained earlier, Mr. Puracal's health was rapidly deteriorating in prison as the gravely inhuman conditions that he was in. Time was of the essence, and the Puracal family launched an international campaign to save his life. All the legal fees and expenses were necessary to accelerate, hasten his release from conditions that would have otherwise resulted in his death. These expenses and costs are clearly proven and documented in our detailed Annex 47 of the brief that we submitted to the court. So clearly, this economic and moral compensation would greatly help Jason and his family to obtain the psychological and medical rehabilitation, finish studies and attorney license, and recover financial independence here in the United States. So in conclusion, a just, comprehensive, and detailed judgment from this honorable court will allow Jason Puracal and his family to ultimately obtain justice and the appropriate reparation. Likewise, it also represents an important opportunity to take a stand on the serious pattern of human rights violations occurring in Nicaragua, and to also seek to remedy structural problems that are related to the justice systems, conditions of detention, and wrongful convictions. Thank you very much for your consideration.
Muchas gracias a la representación de las presuntas víctimas. Finalmente, daré la palabra a la representación de la Comisión Interamericana para que presente sus observaciones finales orales sobre el fondo, eventuales reparaciones y costas. Solicito que indique a la Corte el nombre de la persona que hará uso de la palabra. Muchas gracias.
Gracias. Soy Cristina Blanco, coordinadora de casos de la CIDH, y realizaré la presentación final junto con Ignacio Bollier, asesor de la comisión. Con su venia, señor vicepresidente.
Adelante.
Honorable Corte, la Comisión lamenta la ausencia de Nicaragua, pues la participación activa de los estados en audiencias ante este tribunal posibilita un adecuado funcionamiento del sistema y la efectividad de los derechos establecidos en la Convención Americana, de la cual Nicaragua es estado parte. La Comisión centrará sus observaciones finales en los siguientes 4 aspectos. 1. La privación de libertad del señor Puracal y sus condiciones de detención. 2. La violación de los derechos a la propiedad privada y al domicilio. 3. El proceso penal seguido en contra de la víctima y su deportación de Nicaragua. Y 4. La violación a la integridad personal de sus familiares. Finalmente, la Comisión se referirá a las reparaciones. Sobre el primer punto, no es un hecho controvertido que el señor Puracal fue arrestado el 11 de noviembre de 2010 en momentos en que se hallaba en su oficina. Según la legislación nicaragüense, para proceder a la detención de una persona se requiere una orden judicial escrita dictada por juez competente, salvo flagrancia. Sin embargo, los policías que lo detuvieron no exhibieron orden alguna. Ante la Comisión del Estado se limitó a aportar un acta policial en la que se indicaba que la detención se dio bajo flagrancia por el delito de transporte de estupefacientes, pero no brindó elementos jurídicos ni fácticos que sustenten la existencia de tal supuesto. En consecuencia, la Comisión entiende que al no contarse con orden judicial ni haberse demostrado flagrancia, la detención del señor Puracal fue ilegal a la luz del derecho interno y por tanto violatoria del artículo 7.2 de la Convención. La Comisión encuentra que el arresto fue también arbitrario, en contravención del artículo 7.3, en tanto fue agredido durante el procedimiento según lo refirió la propia víctima en esta audiencia. Por otra parte, Nicaragua no acreditó que los agentes estatales informaran al señor Puracal sobre las razones de su detención, ni sobre su derecho a contar con asistencia consular. La Comisión recuerda que, según la jurisprudencia de la Corte, recae en el Estado la carga de probar que brindó tal información, pues es quien formula una alegación positiva y tiene a su alcance los medios para demostrarlo. Resalta además que la víctima no fue presentada inmediatamente ante un juez, sino que la audiencia preliminar tuvo lugar recién 3 días después de su detención. Por todo ello, la Comisión considera que la privación de libertad del señor Puracal fue contraria a los incisos 3, 4 y 5 del artículo 7 de la Convención. Respecto de la prisión preventiva, la Comisión observa que dicha medida fue fundamentada exclusivamente en la invocación del artículo 173 del Código Procesal Penal de Nicaragua, el cual dispone, cito, que en todo caso el juez decretará la prisión preventiva sin que pueda ser sustituida por otra medida cautelar cuando se trate de delitos graves relacionados con el tráfico de estupefacientes o lavado de activos. En casos como Herrera Espinosa y otros contra Ecuador, este tribunal ha señalado que la gravedad del delito imputado no es en sí misma justificación suficiente para el dictado de la prisión preventiva. Conforme a los estándares interamericanos, la orden judicial debe indicar los indicios que permitan suponer razonablemente la participación de la persona en el delito, perseguir el fin legítimo de evitar la obstrucción del proceso o el riesgo de fuga, ser idónea, necesaria y estrictamente proporcional, además de estar debidamente motivada. No obstante, en el presente caso, el propio Estado afirmó ante la Comisión que la prisión preventiva fue impuesta por aplicación del artículo 173. La información aportada muestra que efectivamente la orden se dictó en función del delito imputado sin demostrarse el cumplimiento de los referidos requisitos. La Comisión recuerda que además de ser violatoria del artículo 7 en relación con el artículo 2, la prisión preventiva automática es también contraria a la presunción de inocencia e igualdad ante la ley. Como señaló la Corte en el caso García Rodríguez, tales normas suponen un trato diferenciado entre las personas imputadas por determinados delitos respecto a las demás. Asimismo, la Comisión advierte que el encarcelamiento preventivo se extendió por casi 2 años y no fue objeto de una revisión periódica. Esto contradice lo señalado por la Corte en casos como Arguelles versus Argentina, respecto a que la detención no debe exceder el límite de lo razonable y debe ser sometida a una evaluación periódica de sus fundamentos para que no se prolongue innecesariamente. La Comisión destaca, además, que el recurso de exhibición personal presentado por la señora Flores fue inefectivo. El magistrado interviniente se limitó a acudir a la sede policial de Rivas para solicitar información sobre el señor Puracal, quien había sido trasladado a Managua 2 días antes. Aunque el juez calificó dicho hecho como anómalo, el Estado no aportó pruebas de que la autoridad haya realizado otras acciones, sino que archivó el recurso. Ello resulta contrario al derecho al control judicial de la detención contenido en el artículo 7.5 de la Convención. La Comisión pasa ahora a referirse al derecho a la integridad personal. De acuerdo con los consistentes testimonios del señor Puracal, no controvertidos por el Estado, durante su traslado hacia la cárcel de Rivas fue objeto de amenazas de muerte y golpes por parte de agentes policiales. Además, no existen registros de su entrada y egreso de dicha cárcel ni del centro penitenciario El Chipote. No consta tampoco la realización de una revisión médica para constatar su estado de salud, sino hasta después de 6 días de su detención. El señor Puracal ha relatado en esta audiencia las deplorables condiciones de detención que debió padecer. Respecto del Chipote, manifestó que fue encerrado en un calabozo pequeño, sucio, sin acceso a luz solar ni posibilidad de hacer sus necesidades fisiológicas. En la cárcel La Modelo sufrió falta de agua potable, aislamiento, malas condiciones de higiene y hacinamiento. La Comisión resalta el impacto acumulativo que tales condiciones de detención tuvieron sobre su integridad personal, las cuales constituyen tratos crueles, inhumanos y degradantes y resultan violatorias del artículo 5.2 de la Convención. Cabe destacar que el relato del señor Puracal es consistente con la información contextual de larga data recibida por la CIDH, que da cuenta de condiciones de detención incompatibles con la dignidad humana, especialmente en el Chipote. Ello coincide
incompatible with El Chipote. It also matches with other international organizations like the Committee Against Torture of the UN, with your concern in Nicaragua due to arbitrary arrests, the lack of income, and overcrowding in prison. On the other hand, the information provided states that the victim did not receive appropriate treatment to face their asthma problems and stomach upset due to the unhealthy environment that they were living in. As declared, the prison authorities did not respond adequately to the burns that he had suffered on his leg, which led to infections, and his request to attend to an external physician was denied. In the case of Hernandez versus Argentina, this honorable court considered that knowing the condition of health of a person in prison, when the state does not provide sufficient health, then it will result in problems. This can be a causal connection between the conditions in prison and the lack of medical attention for Mr. Puracal violated Article 26 of the Convention, aside from Article 5. The victim also pointed out that during their imprisonment in La Modelo, he had to share with convicted criminals. As Article 5.4 of the Convention and the jurisprudence of this honorable court, state parties must guarantee that people are hosted in a separate space than those who are carrying out a sentence due to the presumption of innocence, and the state violated also that provision. With regards to their rights to private property and domicile, it observes that the Nicaraguan law requires a previous warrant to conduct a search, and this can only be omitted in cases of urgency with subsequent judicial validation. It's not controversial that raids to the home and office of Mr. Puracal were done without a warrant, but the state noted that this was an urgent case and it was validated by a judge. However, as pointed out by this court in cases such as Pujol and Perez, a warrant prior is the rule, and the exception is only valid under the circumstances that are strictly foreseen by the law. In this case, the state did not provide elements that justify urgency to support the validity of an exception. Therefore, this action was arbitrary in violation of Article 11.2 of the Convention. Likewise, in both interventions, the police officers seized personal belongings from Mr. Puracal that were not returned, despite the fact that the criminal proceeding was voided. Therefore, the Commission understands that the state violated the right to private property enshrined in Article 21 of the Convention.
With respect to the criminal process in Nicaragua, the Commission would emphasize that, in addition to the lack of information on his right to consular assistance, the authorities also significantly blocked communication with his defense attorney. The representative said that the interviews with his attorney were limited to only 30 minutes, always in the presence of the prison guards. This is incompatible with the provisions of Article 8.2c of the Convention and the standards set by this court, which has sustained repeatedly that the right to defense serves the purpose of providing the suspect with the opportunity to face the charges. As the victim said before the court, he did not receive the service of an interpreter, and this interfered with his ability to understand the criminal process, and he was unable to exercise his right to defense. The Commission would also note that the process against him lasted an unreasonable amount of time. According to the information in the case file, the victim was charged on November 11, 2010, but it was not until July of 2015 that the Supreme Court finally overturned the conviction. That was 5 years later. The state has not proven that the case was particularly complex and that the procedural activity of the defense had contributed to the delay. With respect to the behavior of the authorities, the Commission notes that the Supreme Court took 3 years to deny the appeal, the cassation repeal, for overturning the conviction, and the state has not explained any reason for this delay. Finally, the Commission emphasizes that the delay in the investigations meant that Mr. Puracal would remain 22 months in pretrial detention under deplorable prison conditions, as we have already described. With respect to his deportation from Nicaragua, the state argued that in the exercise of Mr. Puracal was ordered to be deported, saying that he was a danger to public safety. The Commission would recall that this honorable court, in the case of Dorosay and et al., said that the power to determine conditions for entering a country and remaining in its country for foreigners is not absolute. that it must be exercised by respecting judicial guarantees and due process of law. In the instant case, the measure was taken without even notifying the victim of the fact that there was an administrative deportation process against him. At no time was he given the opportunity to exercise his right to defense or to correct his migratory situation, to appeal the decision, or to learn why he was being deported. Nor did they specify any reasons, any security arguments that the state described, because at that point, the trial against him had already been overturned. For all these reasons, the Commission finds that the state is responsible for violating the rights to judicial guarantees, to judicial protection, and to free movement and freedom of residence in injury of Jason Puracal. Finally, the Commission concludes that the state violated the right to personal integrity of the family members of Mr. Puracal because of the suffering they experienced because of his illegal arbitrary arrest, the lack of due process, and the mistreatment that they experienced. As Mrs. Scarlett Flores explained yesterday before the court, and I quote, she was very excited about the future, and all she wanted was an open way. Honorable Court, this will mark a clear restitution for the victim. The Commission would also emphasize the importance of guaranteeing comprehensive remuneration. With respect to the guarantees of non-recurrence, the Commission finds that it is essential for the state to adopt whatever measures are necessary to bring its legislation into line with inter-American standards on pretrial detention, and also to improve significantly the conditions of detention in these prisons. Thank you. Thank you to the representatives of the Inter-American Commission. I would ask
de la Corte se deseam formular alguna pergunta. Pues Diego
if you would
Moreno.
like to ask Judge Diego Moreno. Mr. President, I do. Thank you very much. First of all, I would like to ask a question to the representatives of the victim. Could you please tell us, we do want to have time for the other judges, but could you briefly tell me, unfortunately, we have not had the opportunity in this hearing to hear from Daisy, the mother of Jason, or his brother James, and so I would like to know how they were affected by the fact that we have heard described in this hearing.
Yes, Your Honor, thank you very much for that question. I'm very happy to respond. Yes, as you recall from the description, the narrative given by Jason himself, his mother, the Dr. Daisy Zachariah, was actually detained against her will while she was in Nicaragua visiting her family. She was terrorized. She was in the family home, actually taking a nap, babysitting her grandson Jabu, who has the special needs Down syndrome, when the police entered the house. And so they are held against their will for 6 hours, which is why we believe that she suffered not only a violation of Article 5.1 because of all that she suffered emotionally, but she also had her personal liberty restricted for those 6 hours when she was held against her will. And she suffered quite a bit since then. This is an ongoing thing that, as our expert witnesses pointed out, these traumas stay with you always, right? Jamie, who is Jason's sister, worked very closely with Janice to save Jason's life. Jamie accompanied Janice, went down to Nicaragua on several occasions to try to fight for Jason. She appeared in the news, in the media. She was very much an integral element to this team that essentially ended up saving Jason's life. And she's in the circle of family, she's in the circle of pain, and she suffered significantly since that fateful day 15 years ago.
Thank you very much, Dr. Ankerwab. Both you and Dr. Gonza this is my final question. You are very experienced lawyers, human rights lawyers. You know the inter-American system very well. You've written very prestigious publications under Oxford University Press on the American Convention. And so this is the reason that I want to get your impression on what I'm going to ask. Jazz does not appear in the informe de fondo de la comisión, in spite of you having informed of his birth. So we have an article in our rules of procedure, Article 35, for reglamento de la Corte. What's your take on this situation? What's your legal approach to this situation?
Sure. Well, we can only say that we advised the commission in a timely manner of Jazz's birth, and we submitted that information before the issuing of the informe de fondo of the commission, right? And so we did everything possible from our end to inform the commission of his birth and of his inclusion as a victim in the case. And of course, the state never objected to that. The state at one point was actually participating in these proceedings before the commission. The state did not object. And so we feel that it's fully justified at this point, both from a procedural point of view to include him as a victim, but also from a sense of justice, given that he's suffered quite a bit, as Jason explained, because there's so many lingering effects psychologically and even physically from this case. And then the other aspect is that Jazz has never been able to get to know Nicaragua and this element, this dimension of his family life, of his personality, that truly is important, and it has been denied to him because of this forced exile.
Y si me permite, baja tú. Si me permite, la honorable corte también, como lo
The honorable court would
resaltó
allow me,
Scarlett.
also as
Un momentito que tengo un eco.
highlighted by Scarlett. Give me just one moment, I have an echo.
Perdón. Como lo resaltó
My
Scarlett,
apologies. As Scarlett
para Scarlett
pointed
y la
out,
familia, inclusive
for Scarlett and this
inclusive para
family,
Jason Puracal
and
es
even for
esencial,
Jason Puracal,
que
it is
con las
essential
circunstancias de seguridad
that
y de
when
transición democrática que
security
existan en Nicaragua, la
circumstances
familia
and
tenga la
the
libertad
government goes
absoluta
through
de
a
retornar
transition,
a
the family should
Nicaragua
have the
sin
absolute
ningún
freedom
tipo
to
de
return to
restricción. En
Nicaragua
este
without any
sentido,
kind of
también
obstruction.
Jazz carece
So
de
along these
nacionalidad
lines,
nicaragüense
Jazz
y es un
lacks a
deseo
Nicaraguan
muy profundo
nationality,
sobre
and
todo de
it's
su mamá
a
Scarlett
profound
de
wish,
poderle
especially
transmitir
of his mother, Scarlett, to
este
be able
derecho
to
a
kind
tener
of
esa nacionalidad,
transmit
a
this
ir
right
y
to
venir
him,
al país
to
de
have the
Nicaragua con ella,
nationality,
con
to
Jason,
go to the
a
country
ver
of
a
Nicaragua to and
sus
from, with
abuelos, a
her,
sus
with Jason,
familiares, a
to
sus
visit his
tíos.
grandparents,
Y
his relatives, his
es un
uncles,
sueño de
aunts.
Scarlett
It's a dream
regresar
for
con su
Scarlett
familia
to go
y
back with her
empezar con la
family
frente alta, como
and to
personas
go back
inocentes, con
with
sus
head
derechos
high
restituidos,
as
pero
innocent
en eso
individuals with
de
their
manera
rights restored,
íntegra.
but
Y en
as
eso
a complete
Jazz es
family.
fundamental.
And in
Ella ha
that
tratado
sense,
con
Jazz
mucha
is
dificultad,
very
como
important.
sabemos los
She has
inmigrantes aquí,
attempted, it's
de
very
poder
difficult,
transmitirle
as
esa,
for any
esa
immigrant here,
cultura nicaragüense a
to
Jazz y su
convey
padre,
that
una oportunidad de
Nicaraguan
poder
culture to
conocerlo, se
Jazz.
darían cuenta
And if you
que
had
él
the
es un
opportunity
nica
to meet them, you would
pero
realize
sin
that
el reconocimiento
he's
legal de
Nicaraguan,
esa
but
nacionalidad.
without
Entonces eso
the
quería
legal
agregar como
acknowledgement of
una
his
reparación
nationality. And that's what I want to
también
add, because that is
poder
one of the
volver a tener
reparations.
esos
They
reconocimientos
dream
integrales del
to be
derecho,
able to have
inclusive
that
el
full
señor
acknowledgement
Puracal
of
que
their
vivía
rights,
legalmente
even
en
for
el
Mr.
país,
Puracal, who was living
poder
legally
hacerlo
in the
como una
country,
familia completa.
and to be able
Gracias.
to do it as a whole family. Thank you.
Muchas gracias. Yo no tengo más preguntas, señor
Thank you
presidente.
very much. I have no further questions,
Gracias,
Mr.
juez Diego
President.
Moreno. Yo pregunto
Thank
ahora, juez
you,
Alberto
Judge Diego
Moreno,
Moreno.
si
Now I
desea
ask.
formular alguna pregunta.
Sí, presidente, muchas gracias.
Yes,
Le
Mr. President, thank you
preguntaría
very much. I would ask Dr. Antoviak.
Se me pasó preguntarle
I
al
forgot
señor
to ask
Puracal, pero
Mr.
él quisiera
Puracal,
saber
but
si el
he must know
señor
whether
Puracal
Mr.
fue
Puracal
chantajeado, fue
was
extorsionado
blackmailed or
por la
whether he was a victim of
policía.
extortion by the police.
Él ya nos dijo que no era político, que no estaba vinculado a
He
la política,
told us that he was
pero
apolitical, that
puede
he was
haber
not linked
pasado
to
esto que la
politics.
policía
But
simplemente
what might have
quiso
happened is that the police
ganarse
simply
ahí un
wanted
dinero que no le
to
correspondía.
make a buck when they didn't have the right
Very
to.
much, Judge. I can
Thank
tell you that definitely over the course of this proceeding, my clients, the family members of Jason, were approached by police, even judges at certain points, asking for money, asking for bribes. And this is something that, of course, they found very disturbing. And Janice could tell you even more about it because she was the one who experienced it directly, right? Because Jason, most of the time, was sequestered in a clandestine prison or a center, detention center, and they were approaching Jason's family members. But yes, this happened on several occasions over the 22 months while he was in detention. Thank you.
Otra pregunta, doctor.
Doctor.
El señor Puracal, discúlpeme
Mr.
que me haya
Puracal,
preguntar tan
and I
puntualmente
apologize, I
estos
forgot
días,
to ask
pero
this as
después de
well,
escuchar
but
la
after
versión
hearing
del señor
the
perito, bienvenido
statement
a todas
by the
estas
expert witness,
inquietudes.
a lot of
El
queries popped
señor
up in my
Puracal
mind. Mr.
tenía
Puracal,
enemistades en la ciudad, usted
did he have
sabe,
any
o
enemies
en
in
el campo
town
comercial respecto
or
a las actividades
in
como
his business
agente
sector with
inmobiliario,
regards
si
to his
alguien
activities
quería
as a
que
real
le fuera
estate
mal a
agent?
él,
You know,
usted podía
somebody who
sacarlo del mercado
wished
para
him
quedarse
bad
con eso y
or
no
who
su
wanted to take
inversión.
his slice
Pudo
of the
hacer estas
market.
denuncias
Do you think
o
somebody
estar
might have
detrás
placed a
de estas
complaint
cosas.
against them maliciously or might be behind all of these procedures?
You know, my own personal theory was that it was simple jealousy. We had a foreigner who was doing quite well in a small touristy town, really prospering in a very honest and hardworking way with his real estate company. He was a person of color, and he married a local woman, and this may have generated jealousy. Or at least it may have caught the attention of others. They may have seen his financial resources, his beginning degree of economic prosperity. But then again, these are just theories, and this is only something that we can conjecture about. So.
Okay. Gracias, doctor. Y una última pregunta.
One final question. It's been pointed out, and it was pointed out in the briefs as well, that the judge or this person who acted as judge did not have the requirements to be a judge. In Nicaraguan law, is there has it been included the fact that he did not fulfill these requirements and he was still appointed as a judge to this case?
Is that this judge was not actually licensed to practice as an attorney. He was only 27 years old, and he was actually wanted. He had been formally accused of fraud in another jurisdiction. Soon after this case,
Excuse me,
yes,
who was accused previously? The judge?
the judge himself. Yes,
Okay.
that's right. And then soon after this case concluded, he actually left the country. And so clearly this was a person not at all qualified, not at all in the conditions. Only 27 years old, I might add, at the time. Not at all in the conditions to be participating in this type of case.
And do you know where that man lives now?
The last I heard, he was in Spain, although he may have returned or moved somewhere else at this point. But this was a couple of years ago. I heard that he went to Spain.
I think it would be very interesting to know where does he live now. I think we should try to imagine new things in order to put things in order in the continent. Okay, thank you very much. You have been very kind.
Thank you.
Ninguna otra pregunta, señor presidente. Gracias.
Muchas gracias, pues, Diego Moreno.
Thank you, Diego Moreno. Alberto Borea. I now ask Judge Patricia Perez, do you wish to ask a question? No, thank you very much, Mr. President. Thank you very much, Judge Perez. Now ask Judge Gomez, do you wish to ask a question? Yes, Mr. President. I have two very specific questions.
Could you clarify a little bit more about the consular notification? Because it was mentioned in the testimony of Mr. Puracal that he received the visit of consular authorities of the US while he was in prison at some point. But could you clarify whether the consular authorities were notified at the moment of his detention?
Yes, I would be happy to. Thank you for the opportunity to clarify. No, at the moment of his detention, he was not notified. The consulate was not notified. He was not provided access to the consulate. So in violation of his rights under international law, this did not happen. And I'd also like to point out then in our exhibits that we've presented before this honorable court, there's extensive information about how there was very inadequate consular assistance provided to Jason while he was in detention. And Janice Puracal could also testify at length to that because she was basically the point person who was trying to establish a liaison with the U.S. Embassy, with the U.S. Consulate to support Jason. Time to time, they were able to help him with small things, but ultimately, that assistance was unsatisfactory. We received much more assistance and support from local political leaders here in the United States.
Okay, so just a matter of interest, the assistance had to do maybe with his health, but not with his, let's say, with matters that had to do with due process?
Yes, that's correct.
Okay, so that was the approach. And the second question has to do with some non-repetition measures that you have requested. You mentioned legislative reform or measures that can only be reached through legislative reform and to remove obstacles to the proper investigation of cases like this in Nicaragua. It's a bit generic. Do you want to perhaps be more specific? And I would like to ask, me gustaría también hacerle esta pregunta a la Comisión Interamericana, si tiene alguna observación sobre este tema. But first, the representative of the alleged victim.
Yes, absolutely. So as we've been emphasizing through this entire proceeding, structural reform is so important to my clients, to the victims of these serious human rights violations, because they really care about Nicaragua. They're very saddened by the current state of Nicaragua and the dissolution of the rule of law in Nicaragua. And this conversation also was had between the honorable judges and our expert witness, Professor Brooks, because we're obviously dealing, it's such an intractable and such a difficult situation when we look at Nicaragua, that's controlled by an authoritarian and that controls the rule of law, controls the judicial system, right? And so reforms will be very difficult to come by, right? But that's something.
It's okay. I understand that. That was very clear from what you explained before. The question is, which sort of measures are you? I mean, do you want us just to refer to to the expert witness report, or do you have something to say in your alegato about what particular measures? I mean, for instance, he mentioned an evidence code, just to give you an example. Okay, do you have anything? I mean, very more specific, because you started your final allegation saying that you were going to be very concrete about these things, but then
Yeah,
we're not.
actually, I was very specific. In our ESAP, in our brief before the Honorable Court, it's much more specific. We have limited time during the Honorable Court presentation, so we're not able to get into as many specifics, but I'm happy to entertain that question now. And so, essentially, a legislative reform would be required on different vertices. One of them is with respect to conditions of detention, right? And so those legislative measures would be required to allow for example, the adoption of UN UN standards on the minimum treatment, the Mandela rules, for example, the minimum treatment of prisoners, right? What we're going to need is legislative reform would be required also to allow for this type of innocence petition or request to be even possible within the state of Nicaragua. If you'd like more specifics on that, I could actually refer you to mi asesora, Alejandra Gonza.
It's okay if it's part of your final allegations, your final written allegations. That would be fine.
I could make one reference.
Sure.
One of the references that the court needs to think this case as a case, one of the cases with all the other cases that are in permanente desacato from Nicaragua, to be part of the transition into democracy that Nicaragua will need to go, with the reconstitution of the judicial system as a whole, with the independence of the judges, and how the requirement of what it's needed to be a judge, to be sitting in those instances that you are judging people, and the independence, the impartiality, that's something that is not possible in the regime that the Nicaragua is going on. And it's proven by the context that this case is happening now, a context that is, although it's after the facts of the case, it's already proven in the reports of the Commission and in the different judgments from the Inter-American Court. Thank you very much.
Thank you. Para la Comisión Interamericana, ¿tienen alguna indicación con relación a una medida de no repetición vinculada a los obstáculos de tipo del debido proceso en una circunstancia como la del presente caso?
Sí, señora jueza, en su conocimiento del caso.
Your knowledge of the case of Mr. Puracal, the Commission specifically identified Article 163 of the Criminal Procedural Code, which is not consistent with Inter-American standards for pretrial detention, which establishing the measure of that this should never be automatic, given specifically for drug trafficking charges. So in that sense, in the report on the merits, we said that this is a specific recommendation to the state to adopt changes to this rule in keeping with Inter-American standards. Anything on evidence? Yes, that's it. Thank you, Mr. President. Thank you, Judge Gomez. Judge Perez Manrique, do you have any questions? Yes, Your Honor. Yes, Mr. President, rather. I would like, first of all, to ask the Inter-American Commission, what is your stance concerning the inclusion of the possibility of including Jazz, the second son of the family, in the case as a victim? Thank you, Your Honor. Bearing in mind the time framework of the facts of the case, which last until September 2012, the commission decided not to explicitly include the couple in the report on the merits, but with the venue, with the, may it please the court, we have informed the commission in our final arguments. We reported that the child was born in 2014, and so we understand that the child could therefore be considered. We also said this in our representation before the court. Thank you, Commission. I would like to ask the representative of the victim whether in your final closing, in your final written arguments, if you could please discuss a subject that came up with the questioning of the expert witness, which is what would be the proper procedural standards or regulations that should be on the books in order for questioning a judgment that is incorrect or a conviction that has been challenged legally with respect to the legality of a conviction. The expert witness insisted that spoke repeatedly about a situation involving how it works in the United States, and I would ask if in your final written arguments, if you could perhaps give us an analysis from the perspective of a more general perspective as to what would be the minimum conditions necessary from the procedural standpoint for appealing or challenging a judgment, a verdict of this kind. I have no further questions. Thank you. No more questions. Thank you, Mr. President. Thank you, Judge Perez Manrique. I have a question for the commission. I would like to ask whether you could go into more depth, because I did not fully understand the reasons why you think that there was no violation of the right to circulation and residence for Mrs. Flores and her son. We understand that in the arguments by the representatives, they were saying that they needed to leave Nicaragua. And with respect, and the state on the subject said that they were both Nicaraguans and they could perfectly well have remained in the country. This is why the commission felt that there was not sufficient grounds for arguing that point. But now, after having heard yesterday what we heard, does the commission continue to believe that? The commission understands that the restrictions on the rights of freedom of movement and residence from Article 22 can be both de jure and de facto. De facto would be the effect on the family, but the commission does feel that but maybe the court could give a more specific finding on these arguments, and we will put that in our written arguments. So the commission will take a position in its final written submission. Thank you. No further questions? Before we close this hearing, I would like to remind all of you that in keeping with operative paragraph 11 of the orders by the court of May 12, 2025, that the representatives of the alleged victim, the state, and the Inter-American Commission will have up until July 29th of 2025 to submit your final written arguments and final written observations concerning the merits and possible reparations and costs in the instant case. There can be no extension to this deadline. Finally, I would like to thank the representatives of the Inter-American Commission on Human Rights and the representatives of the alleged victims for appearing before this court and taking part in this hearing. The session is